never be tried in any court of law in Nigeria.
Say it again.
That's what the law says.
Say it again.
Anybody standing in trial or coming to try me is a terrorist. That's what their law says.
As simple as that.
Not me.
As simple as that.
Section 2, subsection 3F of Terrorism Prevention and Prohibition Act. That's what it says. Any court considered to try me is committing an act of terrorism.
Yes.
Very clear. You cannot violate a treaty that Nigeria entered into and then come to try that very person is not done anywhere in the world. So you must be aware of that. So that is why there is all these ridiculous delays. That is what Supreme Court said. I did not jump bail. My home was invaded. They came to kill me and I survived. They came to Kenya to kidnap me, brought me back to this country and seeking to try me, which the law says cannot happen. You cannot violate a treaty that Nigeria entered into and then hope to stand on that illegality to conduct a trial is not done anywhere in the world. And it happened in my case. They're here that distort the news. You don't know what law is. You don't know what justice is. Where's the news agents of Nigeria? What are they? You don't know that God is a God of justice. You don't know that? That God in heaven is a God of justice. You don't know that?
Hello everyone and welcome back to Oba's Trending Gist. Today, we are diving deep into a legal earthquake that has just hit Nigeria. This is big and you want to hear every details. So, the Nnamdi Kanu terrorism trial has just taken a jaw-dropping turn. The IPOB leader has sensationally announced in court that he will not be opening his defense, claiming there are no legitimate charges against him. This is a complete pivot from his earlier intention to summon witnesses. Justice Omotosho has now set November 4th, 5th and 6th for final written arguments, following Kanu's bold assertion that the prosecution hasn't proven any case. This move isn't just charges of strategy, it's a direct challenge to the very foundation of trial, forcing a critical reevaluation of the prosecution's evidence and charges. Alright, let's peel back the layers of this extraordinary development, and I'm really keen to get your thoughts in the comments. This is where the Gist family comes alive. So, to recap, Nnamdi Kanu was for a time preparing to mount a defense. He even put a written request to summon witnesses, a perfectly standard and often crucial step in any legal battle to present your side of the story, bring in evidence and challenge the prosecution. But then, boom, he tells the court, hold on, I'm not going to do it. His reasoning, he asserts that after going through the entire case file, he found no legitimate charges against him. He believes he's been subjected to an unfair trial. And if there are no real charges, why bother defending against them? This is just about the strength of evidence. It is a claim that the very basis of the trial is flawed or non-existent. He's essentially saying, you haven't even laid a proper gloves on me, so why should I swing back? Now, Justice James Omotosho, presiding over this high-stake case, didn't just brush this aside. He instructed Kanu to put his declaration in formal written statement and make sure the prosecution gets a copy. This makes his stance official and allow the prosecution to formally react to this monumental shift. And get this, the judge even recommended that Kanu seek guidance for criminal law specialists about the implications of choosing this path. That advice right there tells you how serious the court views this decision, hinting at the significant legal ramifications. Think about it. A terrorism trial, and the defendant say he won't defend himself because there's nothing to defend against. What does that signal to you? Is Kanu making a powerful strategic move to expose what he sees as a hollow case, or is he taking an incredibly risky gamble that could backfire? I want to know what you, my Gist fan, think about this bold play. Drop your insights below in the comment section. We'll talk about it there. Let's transition to my critical take on this truly unprecedented situation. Nnamdi Kanu's decision to refuse to open his defense is a legal chess move of epic proportion, and it's fraught with both potential brilliance and immense danger. From one perspective, this could be seen as an extremely calculated and deviant act if Kanu genuinely believes, as he claims, that the prosecution has failed to establish any legitimate charges or present sufficient evidence. Then, refusing to defend essentially dares the court to rule against him without counter-argument. It puts the entire burden squarely back on the prosecution to prove their case beyond all reasonable doubt, with the added pressure that the defense believes there's nothing substantial to doubt. This move could potentially highlight glaring weaknesses in the prosecution's case, particularly if the court itself struggles to find a compelling basis for the charges after reviewing the final written arguments. It's a statement that says, your case is so weak, it doesn't even warrant a response. You see? So, however, we cannot ignore the inherent risk. By refusing to present a defense, Kanu forgoes crucial opportunities. He loses the chances to call witnesses who might provide alibis or discredit prosecution's testimonies. He can't introduce his own evidence to create doubt or present an alternative narrative. While he asserts there are no charges, the trial is undeniably ongoing, and a court will eventually render a judgment based on the information presented. Without a defense, the court will primarily be left with the prosecution's narrative, unchallenged by direct counter evidence. Justice Omotosho's recommendation for specialist advice isn't just a formality. It highlights that this strategy could have severe, perhaps unforeseen legal consequences, especially in any potential appeal. The upcoming written arguments will now be critical, as they are the final opportunity for both sides to formally articulate their positions before court decides whether Kanu indeed needs to present a defense or if a ruling can be made based on the prosecution's effort alone. This truly is a high-stake moment in Nigeria's jurisprudence. So there you have it, folks. The latest seismic shifts in the Nnamdi Kanu trial. What are your ultimate conclusions on this bold move? Is this a game changer that will expose flaws or a perilous gamble? Make sure to share your thoughts in the comments. If you found this breakdown insightful, please hit that like button, share it widely, and if you haven't already, subscribe to Obas Trending Gist and click the notification bell so you are always in the loop. Until next time, stay informed, stay engaged, keep the conversation going. Peace out.